My name is Christopher Smith. I'm a personal injury and civil rights attorney here in Nashville, Tennessee. And today we're going to talk about mediation and what you need to know about mediation from the plaintiff's perspective. We are plaintiff's lawyers, after all, that's what we do. So most cases will settle. That is increasingly the way that cases get resolved. And not all the time, but often those cases will settle in a process called mediation. Now, mediation is kind of a hybrid formal and informal process. And I say that it's formal because there are formal rules of the Tennessee Supreme Court, or every state Supreme Court, that governs that process. Certain rules of evidence, confidentiality that kind of govern, so anything discussed in a mediation, any documents exchanged, and these sorts of things may not necessarily be admissible in the actual matter lawsuit. If there is a pending lawsuit or if one is yet to be filed, what happens in the mediation cannot be put into the lawsuit, for example, or you can't subpoena the mediator to testify. So those sort of formal rules apply, but it's really informal in the sense that there's no judge, there's no jury, there's no formal decision that is made. It's basically just an agreement between two parties to enter into a contract, a settlement agreement, if that's what's going to happen, if the case is going to settle, that day. So it's a combination of those two things. There's no judge, there's no jury. It's different, for example, from arbitration in that way. And generally speaking, it's a pretty good system. Now I want to talk about the mediator and the choice of mediator and why I think that's important. Ultimately, the object for the plaintiff is to figure out how much money the other side has that day. And then you think about, well, will I take that? Would I accept that? The job of the mediator is to get both parties to that point where they might consider settling the case. What's the amount of money that the defense is going to have to pay to get the case settled, and will the plaintiff take that? And if you can get into that sort of zone of reasonableness, then hopefully the case will settle. So there is quite a bit of work that the mediator typically will have to do, not in every case, but in some of the more contested, difficult cases. There might be some handling of different personalities. You might have a defense lawyer or a defense insurance adjuster who misses the case, just doesn't quite comprehend the exposure. And, so that may be your problem. You may have on the plaintiff side a plaintiff who grossly overvalues his or her case and, is unreasonable in terms of expectations. And so then the job of the mediator is, well, we got to get this plaintiff to see reality in terms of, what's really possible, what's really realistic. And so how the mediator navigates those two different, worlds is very important. And so what we always try to do is select the right mediator for the case. Not just anybody will do. And if you ask around town or look online, you might find, some are better than others. And it's important to choose the right one. Okay, so let's talk about what happens in the mediation. Typically, let's say it's 9 o'clock in the morning and the plaintiff routinely opens with a number, and it's usually the upper end of reasonable. It's a number that you don't expect to get. It's a number that has some sort of baked in negotiation to it that you're going to move off of it. So there's some strategy in how high do you place that number, before you start making your counters and moves. But then the mediator relays that offer to the other side, and hopefully you get a counter offer. And it is not unusual for that counter offer to be something that is kind of insulting to the plaintiff. And that's just the way that this goes. So you have to be prepared for that. If the plaintiff starts at $1 million, they start at $5,000. And it's death by 1,000 cuts, or walking across Siberia barefoot, that you try to meet somewhere hopefully towards the middle, although probably not. I mean, usually in these negotiations, the plaintiff moves bigger and moves more to get to the number. And that's how it sort of goes, because the plaintiff starts so much higher than he or she reasonably expects to get. And that's sort of baked into the process. It can be kind of a long day, the mediation process, for this reason. I mean, if you start at $1 million and they start at $5,000, you might be there all day. And it can be quite boring. It's kind of a roller coaster emotionally, because you're there on a case, and if you're one of our clients, it's a significant case that may involve the death of a loved one or some serious injury, and so emotions are high. There's a lot of downtime where you're just waiting on the mediator, waiting on the counteroffer, waiting for something to happen, and then when it does happen, it's not usually a good thing, because it's some low number or some very small move from the low number. And this process goes on all day. And the idea, I think, I mean, this is my editorializing a little bit here, is that there's a psychological element of trying to grind the plaintiff down into accepting some number because the process is just so unbearable. So psychologically, you have to be prepared for that concept. And physically, you have to be prepared. I mean, you have to bring water, stay hydrated, bring a snack, bring an iPad or something, a book, whatever, just something to kind of keep yourself mentally kind of fresh and not so just fixated on the mediation all day, because it can be quite miserable if you're not sort of prepared for that. So that's one of the reasons I wanted to do this video. What happens if you succeed? If you reach an agreement, typically they will draft something up in the mediation, and it can be handwritten, which I have seen. The mediator might write it on a legal pad by hand and just get the agreement in principle hammered out, and then later the parties will kind of draft a formal document, a formal settlement agreement, and hopefully, you could get your check, get paid in 2 to 3 weeks, maybe. Sometimes it can take a little bit longer, but that's typically the process. So, I always say, if you can get a reasonable number, then it's worth taking, because you're talking about a guaranteed result, guaranteed settlement proceeds, in the next couple weeks. So that's a nice thing about mediation versus going to trial, risking it, because you kind of have to think, well, at the end of the mediation, there's money on the table. How much money? Don't know, $5,000, $10,000, whatever it is. Are you going to risk that to go forward and possibly get more? Sometimes that's the case, so let's talk about when to walk away from a mediation. We usually go into a mediation with some notion of where the case should settle. What's the reasonable range that we will settle? And we do not typically say, we've got a bottom line hard number, because we try to preserve some flexibility. But we have a notion of where this case should settle. And when we walk away from a mediation is when we begin to sniff out, based on the moves, the counteroffers that the defense is making, when we begin to sniff out what we think they've got that day, what their valuation is that day, how much money they've brought to the table, and that number is just no way. There is no way it's going to settle the case. So if we can get to that determination, we will walk away from a mediation and either continue with the case or continue negotiations and just say, this is why your valuation is wrong. This is why ours is correct. This is why you need to get more money to settle this case. Typically, though, we don't walk away from mediations. We just say, let's find the highest number they've got today and then consider whether to take it if it looks like it's going to be in that range of reasonableness where we can, in good faith, recommend to our clients that you take that settlement. In the age of the COVID pandemic, mediations can be completely over the internet, and our clients can be at home or some separate office or wherever they are, and we all sort of tune in to the mediation. That process sort of works the same way. It's just that everybody's a little square on the computer, and the software with Zoom sort of replicates that experience of separate conference rooms. They have what's called breakout rooms in the software, so that we can be in a little Zoom room with our client talking, just us, and the defense lawyers and their client can have the equivalent. So it works quite well, I believe, and is okay. I will say, I think it's important on the plaintiff side for mediators to meet our people and to evaluate them and to understand how they might present at a trial, how a jury is likely to react to them. That can be a little difficult over Zoom. That can be difficult behind a mask. So, I do prefer that, if possible, that we do it in person, at least for the mediator to meet our client. So I hope that sort of overview helps you understand kind of what to expect from a mediation if you're one of my clients, or if you just happen to have that going on and are searching YouTube for that. So I hope it helps.